Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
Hey listeners, it's Lindsay Smith-Rogers. Today, the Supreme Court has issued a ruling on mifepristone that keeps the abortion medication available without a requirement that patients receive it in person. Johns Hopkins professor Joanne Rosen is a lawyer who closely tracks litigation related to access to reproductive health services. She joins Dr. Josh Sharfstein to talk about what happened in this particular case and the broader context, an ongoing legal battle about what the end of Roe v. Wade really means. Let's listen.
Joanne Rosen, thank you so much for joining me again here on Public Health on Call. There's been another high-profile mifepristone court decision, and I wanted to call you up and see what you think about it.
Great. So I assume that the impetus for the call is the decision that the Supreme Court issued on May 14th. And that is all around a case that the state of Louisiana initiated against the FDA back in October, where they were challenging a decision that the FDA made about mifepristone in 2023. And in that 2023 decision, the FDA decided, on the basis of extensive evidence of safety and effectiveness, that they would remove what had been a long-standing requirement that mifepristone could only be obtained in person. So they removed that requirement, and that allowed mifepristone to be made available through the mail, and including following a telehealth appointment that a person could have with their physician and get the prescription via telehealth and then mailed to them. Louisiana then brought this challenge, and they filed it in a federal trial court in Louisiana. And right at the outset of their lawsuit, they asked the district court to enter a preliminary injunction that would reestablish the in-person dispensing requirement while their challenge went on. And the FDA, interestingly, represented by members of this administration, objected to the request to reimpose the in-person dispensing requirement. And they also asked the district court to pause its proceedings for the time being because the FDA had announced that it was undertaking its own extensive safety review of mifepristone. And so the FDA said, wait, hold up. We're in the midst of a review. Don't proceed with the trial.
Right.
And then the district court rendered a decision in around April, I believe, where the district court said that it thought that Louisiana had a reasonable likelihood of succeeding on the merits of its challenge to the FDA decision, but it refused to reinstitute the in-person dispensing requirement on a temporary basis, which would effectively have meant they were overriding the FDA's decision. And they agreed with the FDA's request to pause the trial proceedings and the district court said, it's in the public interest for the FDA to conduct the safety review that it has undertaken. And then Louisiana swiftly appealed that decision to the Fifth Circuit Court of Appeals. And they asked the Fifth Circuit, hey, can you please reimpose the in-person dispensing requirement while we proceed with our appeal in front of you?
And then the Fifth Circuit did agree with Louisiana. Is that right?
Yes, they did. They agreed. They reimposed the in-person dispensing requirement on this temporary basis while the appeal was being heard. And in addition to the FDA being a party to this case, two drug companies that are the main manufacturers of mifepristone, also parties to the case, the two drug companies really quickly went to the Supreme Court and asked the Supreme Court to block the Fifth Circuit ruling and essentially allow the FDA's 2023 decision to remain in place while the appeal in the Fifth Circuit was underway. You know who didn't participate in the request to the Supreme Court to ask the Fifth Circuit order to be stayed was the FDA itself. And the
FDA was quiet in front of the Supreme Court.
FDA was quiet. And when the drug companies filed their emergency motion to hold the FDA decision in place, the Supreme Court invited the FDA to file a brief and also invited Louisiana to file a brief. So the FDA was quiet and did not respond to the invitation to file a brief. So where we're at right now is essentially the status quo with respect to mifepristone being available without the in-person requirement is the way we're at right now, and the appeal will continue in the Fifth Circuit.
Right, because the Supreme Court actually overrode the Fifth Circuit in its last decision, sent it back to them while allowing for telehealth prescriptions of mifepristone in the meantime.
Precisely. It looks like it was a 7-2 decision on the part of the Supreme Court. They didn't issue reasons for granting the drug company's request to allow the FDA rule to be there, and that's customary. But there were two justices, Justice Thomas and Justice Alito, who filed dissenting opinions. And Justice Thomas said allowing mifepristone to be mailed is a criminal offense because it violates the Comstock Act. And Justice Alito said that mailing mifepristone is essentially engaging in a criminal enterprise that is perpetrated to undermine the impact of the Supreme Court's decision in Dobbs. So two very loud dissents in that case.
Let's talk about the first one from Justice Thomas and the Comstock Act. Can you remind me about that law?
Sure. And Justice Thomas often is known for saying the quiet parts out loud, which is what he did here. The Comstock Act is actually one of the grounds for challenge that Louisiana has raised in its lawsuit against the removal of the in-person requirement. Comstock Act is a federal statute that goes back to 1873, so over 150 years old. And one of the things that it's very broadly worded, it says that it is a federal offense, a felony, to ship any articles, devices, instruments, or other things that can be used to produce an abortion. It's an offense to ship them through the mail or common carriers. So that is the very broad wording of the Comstock Act. Really important is that throughout its history, and it again goes back to long before Roe versus Wade created a constitutional right to abortion, it has long been understood not as an across-the-board ban of mailing or shipping abortifacients, but as a ban to use the mails to ship abortifacients where they will be used unlawfully. And there have always been, even pre-Roe, where there were really strict state abortion bans, always been exceptions that have allowed for abortions in limited circumstances. And so it is not it is not really in accordance with the way the Comstock Act was interpreted to say it never would allow using the mails to ship an abortifacient.
So you have one dissent that really emphasizes this. Do you think that the fact that that was a dissent and not in the majority opinion means that the majority of the Supreme Court doesn't believe that the Comstock Act should really have a major outsized role in determining mifepristone regulation in 2026?
It's impossible to say. I think it may be meaningful that no one else signed on to that opinion. So it may mean that they're not prepared to wade into this at the moment. Maybe it means that they don't see it's necessary to do it generally, but I don't know. When the original challenge to the FDA's regulation of mifepristone in the Alliance for Hippocratic Medicine case was argued, both Justices Alito and Justice Thomas raised the application of the Comstock Act during oral argument. None of the other justices did. And while the court dismissed that case on the technicality that the plaintiffs lacked standing, none of the justices saw fit to address the relevance of the Comstock Act in that case.
Well, certainly you could say there's not a majority of the court that feels as strongly as Justice Thomas does.
I think that's fair.
Yeah.
Yes.
But we'll see. And now let's turn to Justice Alito's dissent. Tell me a little bit more about what he was arguing.
It is the tone of the dissent, I'd say, is angry and exasperated. What he is arguing is that I can just quote a piece of it. He says, what is at stake, meaning in the FDA is allowing mifepristone to be sent by mail through telehealth care. What is at stake is the perpetration of a scheme to undermine our decision in Dobbs, which restored the right of each state to decide how to regulate abortions within its borders. And some states responded to Dobbs, this is still the quote, by making it even easier to obtain an abortion. Louisiana, on the other hand, and this is no longer a quote, but a paraphrase, Louisiana, on the other hand, sought to ban all of abortions. And the ability to mail mifepristone, which is what the FDA made possible through its decisions, Justice Alito says, really undermines or thwarts the purpose of giving each state the ability to regulate abortion as they see fit.
So this really gets to this big question after Roe fell in the Dobbs era about what it really means for states to be able to set their own laws, because there are states that permit abortions and there are states that don't. Is Alito trying to argue for a particular conception of the law after Dobbs, do you think, here, or what's going on?
I think there, at least from Alito's perspective, I think there is real debate about what Dobbs actually did. He believes that Dobbs, it's so bizarre to say he believes because he actually authored the opinion, but it doesn't mean that there's a consensus or a uniform understanding of how far Dobbs goes and what are the limits of Dobbs. But Dobbs absolutely eradicated a nationwide constitutional right to abortion and made clear that the regulation of abortion would now be left to legislatures, and different states would approach the question in different ways. What Dobbs didn't do was institute a nationwide ban on abortion. And there has been post-Dobbs what one legal scholar, I think, has quite aptly described as a cat and mouse game between anti-abortion states and anti-abortion organizations that are trying to find ways to shut down abortion overall, and abortion protective states and reproductive rights groups that are seeking to expand and protect abortion broadly. And so sort of one measure is countered by a countermeasure.
Both are trying to define what that big Supreme Court case from a few years ago really meant.
I think that's correct. Part of Louisiana's argument is that because they too have to establish that they have legal standing to challenge an FDA decision, and part of their argument on standing is that the fact that women in Louisiana who seek to end a pregnancy can have a telehealth medication appointment with a doctor in another state and then obtain their medications through the mail undermines Louisiana's sovereignty and ability to enforce its own abortion ban. And they've said further, because you need to establish this for standing, that you've been injured and that the injury is caused by the respondent. And so they're arguing that the FDA's, I would say, safety and evidence-based removal of the in-person dispensing requirement has caused them to experience an injury to their state sovereignty.
In a way, simply by asserting standing, they're making an argument in their mind about what that Dobbs decision actually means.
Yes. Yes.
Now, let me just very briefly ask you about other cases on mifepristone. I know the Louisiana case isn't the only one. Is there a way just to tell me, are there majorly different issues coming up in those other cases?
I wouldn't say majorly. I would say slightly, but I look at all of these cases as the offspring of the original Alliance for Hippocratic Medicine case, and these are sibling cases. So there is the Louisiana cases we've discussed. There's a very similar case filed jointly by the states of Texas and Florida that's being litigated in a federal court in Texas. That case is challenging the 2023 removal of the in-person requirement, as well as every other regulatory decision, including the original 2000 FDA decision to approve mifepristone. So they're challenging everything. And if they were to succeed, mifepristone would be removed nationwide. So it would essentially shut down the single most common medication abortion protocol in the country. 63% of all pregnancies that were terminated as of 2023, which is the latest year for data, were terminated through medication abortion, and the actual number is higher than that. And 27% of all abortions in the first half of 2025 were telehealth medication abortions. And then the third case, the third sibling, is filed by Kansas, Missouri, and Idaho, and it is being litigated in a court in Missouri. And I think that one challenges a 2016 FDA decision that significantly expanded access to mifepristone, as well as the decisions to remove the in-person dispensing requirements.
Before we go, I want to ask you about two things that are related to the law and these decisions, but maybe not entirely about them. The first is a statistic that I saw that the number of abortions in the country has actually gone up. How do you think that is affecting this litigation?
I think it's probably one of the catalysts for these ongoing cases against the FDA. You're right. The number of abortions in the country has gone up every year since Dobbs. So rather than Dobbs, we knew that Dobbs would not put an end to abortion because some states, 29 states as of right now, continue to protect legal access to abortion. But many expected that the number of abortions per year would drop because many states would restrict or ban it. Not the only reason, but one of the primary reasons that the number of abortions has gone up rather than dropped is the availability of medication abortion provided through telemedicine. And so, if Louisiana and all of these other states could somehow pinch off either mailable mifepristone access or mifepristone altogether, the number of abortions year over year would go down.
The second question I want to ask you has to do with the popular support that exists for access to mifepristone, including access without an in-person requirement. How do you think that is shaping the context of this litigation?
I suspect that the federal government is trying to thread a very difficult needle. They have been facing well-reported criticism from some very strong anti-abortion groups for failing to move strongly and quickly enough to conduct their review of mifepristone, and presumably there's a desire that it be dramatically restricted. Abortion, at least in the earliest, abortion remains, a majority of Americans support access to abortion, and in particular, abortion in the earlier parts of pregnancy, and there is very strong support, as shown by different polls, for medication abortion. And so I assume that perhaps at least part of the reason that the FDA declined to file a brief in the Supreme Court recently was they didn't want to have to take a public position one way or the other. And the drug manufacturers did the work for them.
And that's maybe where I want to end. If, in fact, FDA gets what it asked for back in the district court, gets this pause,
Yes.
and then decides it's going to do its own analysis, that doesn't end the issue. That just switches the context. And the question will be, can the FDA do a serious and thoughtful review based on science in the midst of all this politics?
It's a really important question. And Josh, you and I both know very well, we know that they are capable of conducting a science-based, cautious review because they've done it for 12 or 15 years with respect to mifepristone. Whether they can do it in the current politically very fraught environment, let me just say, yes, they can. Whether they will is unclear.
Joanne Rosen, so great to catch up with you about these cases. Thanks so much for joining me on Public Health on Call.
You're welcome.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, Stephanie Desmond, and Rachel Walsh. Audio production by Michael Bonfils, Matthew Martin, and Philip Porter, with support from J.B. Arbogast, Spencer Greer, and Chip Hickey. Distribution and social media by Rachel Walsh, with support from Nick Moran and Brianna Iacovelli. Follow us on Instagram and Blue Sky at Public Health Pod for more public health takes and special content. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.